How when a prosecutor knows of clear and convincing evidence
Okay, let's go over
establishing that a
exculpatory
defendant in the
evidence and what it can
prosecutor's
do for you. Throughout my
jurisdiction was
years,
convicted of an offense that the
I've talked
defendant
to
did not
people,
commit,
and
the
they asked
prosecutor
me
shall
if
seek
I
to
knew a
remedy the
lawyer
conviction.
or a good lawyer that would help them have them exonerated because of exculpatory evidence. And I've dealt with civil rights attorneys, and let's just say if you don't have the rules of professional conduct at hand, you're never going nothing's ever going to get done the right way. All right. That will get you through the day. The rules of professional conduct and the code of judicial conduct, okay? The Sixth Amendment of the United States guarantees you effective assistance of counsel, and those requirements are in the rules of professional conduct and the code of judicial conduct, okay? That's what gives you effective assistance of counsel. Without effective assistance of counsel, you won't get a fair trial. And without a fair trial, due process doesn't exist. All right, so exculpatory evidence is any information or material that leads to clear defendant of blame, show innocence, and reduce potential punishment. It is it is the opposite of inculpatory evidence, which points to guilt. Show more. Okay, the Brady rule, based on the U.S. Supreme Court case Brady versus Maryland, prosecutors must hand over favorable and material evidence to the defense. And I did a video before showing you that the Supreme Court warned prosecutors about doing that. That was in 35, 39. I'll get to that later. But in there they mentioned that the prosecutor, in seeking justice, they are there to seek justice, and their obligations is that much to the defendant as anybody else to see that justice is served. Their job is not merely to prosecute; it's to see the innocent aren't harmed and the guilty don't get away. Okay, the Brady rule. Prosecutors must hand over favorable evidence and material evidence to defense. And that doesn't happen a lot. That's why there's so many cases where they're overturning wrongful convictions. And overturning a wrongful conviction can be easy using the rules of professional conduct. Due process, withholding this information violates the defendant's constitutional right to a fair trial. Impeachment material rules requiring sharing details that challenge the truthfulness of government or police witnesses. Common examples: alibi proof, receipts, logs, and videos showing the accused was elsewhere when the crime happened. DNA mismatched biological material from a crime scene matching someone else instead of the defendant. Okay, so that's the Brady rule. They can't withhold exculpatory evidence, but they often do to procure a conviction. The Supreme Court said they are allowed to strike hard blows, but not foul blows. And withholding exculpatory evidence is hitting you with turduckens, prehistoric-sized turduckens. This is like foul, beyond foul. Okay, so exculpatory evidence can be used to overturn a wrongful conviction. Now, I have exculpatory evidence, but no matter what I filed, nobody will listen. I've been to a lot of different places. Okay, so let's go to the rules of professional conduct. Okay, we'll go to the rules of professional conduct. Okay, rule 3.8. Okay. So I was trying to get some volunteers. I went to the state's attorney's office and told them I have my exculpatory evidence. It's your job to exonerate me. You know the rules, and so do I. says right here, when a prosecutor knows of new credible or material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to the appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless court authority is delayed. Okay, when the state's attorney's argument was with me was the evidence was exposed to my attorney, and it's not their fault that he didn't give it to me. But neither of them used it, and disclosure law requires that everybody in that courtroom reveal that exculpatory evidence. Just because my attorney didn't expose me to that, didn't give it to me, didn't allow me. It was the public or the state's attorney's office to do so. So the evidence they withheld would have proved there was no probable cause. The duty of a public prosecutor to seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge that a prosecutor knows is not supported by probable cause. Make reasonable efforts to assure that the accused has been advised of the right to and for obtaining counsel. And not just obtaining counsel, obtaining effective assistance of counsel. Okay, and effective assistance of counsel, that's them abiding by the rules of professional conduct. So your lawyer didn't abide by the rules of professional conduct, and neither did the state's attorney. The judge didn't enforce them, and as you well know, that's misconduct. Violating any of the rules of professional conduct is misconduct, okay? It is professional misconduct for a lawyer attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so with acts. I'm sorry, I can't see that good. Acts of another. Okay, so violating the rules is misconduct. Inducing others, they don't have to, because it says right here, reporting misconduct is mandatory. All right, so nobody does that. Reporting professional misconduct. A lawyer that knows that another lawyer has committed violations of rules of professional conduct shall inform the appropriate professional authority. A lawyer that knows that a judge has committed a violation of the code of judicial conduct that raises substantial question to the judge's fitness of office shall inform the appropriate authorities. So violating the rules of the code is reporting that misconduct is mandatory, and both the rule of professional conduct and the code of judicial conduct is mandatory for all lawyers and judges. So they withheld this exculpatory evidence from me. Everybody did. The judge, when I tried to talk to the judge said talk to your lawyer, but my lawyer wouldn't talk to me, which communication is mandatory. In my case, I kept every time he said, I don't work for you, but how can you be in the court supposedly representing me and then telling me you don't work for me? For the most part, he tried to convince me to take a plea deal, which was not defending me. That wasn't competent. He's supposed to defend me as if it was his own life, liberty, and pursuit of happiness were on the line. So truthfulness and statements to others, they lied, especially about the rules of professional conduct in a court of law. Not mentioning the rules is just as well as lying about them. Trial publicity, that happens. Impartiality and decorum of the tribunal, okay. A lawyer shall not seek to influence a judge, juror, or prospective jurors, or officials, or means prohibited by law. So it's not just jurors, but it's the judge and the other lawyers. And it's not hard to persuade them because everybody consistently violates the rules of professional conduct and the code of judicial conduct on a daily basis. And that's what makes it so easy to overturn any case. You can cite, and no matter what courtroom you're in, you can cite anybody for a conspiracy against rights under the color of law. And it starts with deprivation of rights by your lawyer not abiding by rules of professional conduct, fairness to the opposing party. People told me, okay, you always talk about prosecutorial misconduct, but about what other cases? This is when you use this rule: fairness to the opposing party or counsel. Okay, a lawyer shall not unwillfully obstruct another party's access to evidence. Okay, so you'll want to use that. And fairness to the opposing party and counsel. So when the state's attorney told me they gave it over to the counsel, my counsel, she got mad when I says, "Oh, that's what you call fairness to the opposing party." She says, "And counsel." I said, "You were fair to him, but he's not being fair to me, and you're supposed to be fair. So it's supposed to go through me first. And no decisions can be made by my attorney without my consent. I have to give informed consent. And that informed consent requires reasonable knowledge to make an informed decision, to give informed consent. And that reasonable knowledge will be legal knowledge, at the very least, going over the rules of professional conduct, code of judicial conduct, explaining to me what due process is, what effective assistance to counsel is, how to obtain it and maintain a fair trial. But none of that was reviewed with me, which is a lack of disclosure. Look up the disclosure. Disclosure is mandatory. So I believe this will meet the requirements of disclosure, as well as discovery. Meritorious claims and contentions. What they were saying happened in court. Every allegation they made was a lie. If I had been afforded the opportunity to review discovery, I could have gone over to hospital reports, police reports, and shown and proved myself that there were no meritorious claims and contentions, making my statements, making my giving me meritorious claims and contentions, and that meaning they had none. Okay, so anyways, you're seeing that the state's attorney's job, Rule 3.8, special responsibilities of prosecutor, is if they become aware of exculpatory evidence, they have to overturn, make remedy that situation. Come on. So I have that exculpatory evidence, and like I said, let me show you. I've been to a lot of different places, a lot of different people, and nobody answers me. Sometimes I get an answer, and rarely. And when I do, they tend to avoid everything that I bring up. I don't know why this is not working. Okay, look, here's a letter from the U.S. Department of Justice, or to the, I went to the FBI office. I wrote to them. I started doing this stuff in the 80s, but I was surprised in the 90s. That was for the second wrongful conviction I was trying to overturn in the 90s, and this is a response to your complaint filed with our office June 17th, 1992, Your correspondence has referred to the Civil Rights Division, Department of Justice for its review. Division will determine if your complaint constitutes the possible violations of the Civil Rights Act. Any questions you may have regarding this disposition on your complaint should be addressed to the Civil Rights Division, Department of Justice, 10th Street, Constitution Avenue. Okay, so I did, but they never answered me. See, this is actually from the FBI. I went to the FBI and filed my complaint. And then I went over the conspiracy against rights under the color of law, and I cited judicial misconduct, ineffective assistance of counsel, and prosecutorial misconduct. And then I went over the code of judicial conduct, how the judge denied me my right to be heard, and when my lawyer went and told her that I was going to come out there and demand my right to be heard, and demand that she cite him for ineffective assistance of counsel. Well, I never made it back out to the courtroom. They convicted me, took me into the back, into the lockup, and I was supposed to come back out to the courtroom, and I was pissed at everybody. Ran off at the mouth, and so my lawyer went and told the judge, that reporting misconduct is mandatory in the rules and the codes. This was me going to the
Rule 3.8. Special responsibilities of a prosecutor, G. When a prosecutor knows of new, credible and material evidence creating a reasonable likelihood that a conviction.
Yeah, it was at Northwest University Center for Wrongful Convictions. I asked him to accompany me to the state's attorney's office and overturn a wrongful conviction using exculpatory evidence. Requirements of the Rule 3.8, rules of the prosecutor, special rules of the prosecutor of professional conduct. I got chased. Yeah, they got mad and told me that's not the way they do things, and first just leave a little note, post-it notice, I don't know, but just give them a brief explanation and they'll get around to me. And I said, well, this could be over and done with, if you go with me to the state's attorney's office and have them exonerate me. He says, how do you expect that? So I pulled out the rules of professional conduct, started going over it, and they got upset and chased me out. Okay, so, and state's attorney, I got chased out of state's attorney's office as well a few times. They told me, they don't work for me. I can't tell them how to do their job. I wasn't telling them how to do their job. I was telling them to do their job. The law is telling them this is your job.
Convicted defendant did not commit an offense of which the defendant was convicted. The prosecutor shall sad face 1. Promptly disclose that evidence to an appropriate court or authority, and e. undertake further investigation, or make reasonable efforts to cause an investigation, to determine whether the defendant was convicted of an offense that the defendant did not commit. H. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction.
Okay, that's all I want to do, all right?
What is it called when a judge and lawyers work together and violate the rules of professional conduct and the Code of Judicial Conduct to deny a fair trial? +1 when a judge and lawyers work together to manipulate proceedings and deny a fair trial. It is generally referred to as judicial. What is it called when a judge and lawyers work together and violate?
That's right. All right, I get the point.
Okay, this is what I'm dealing right. When a judge and lawyer.
Okay. Now, for some reason,
what is
it's not going down.
Okay, this is what I'm dealing right now. The power went out and gave me a lot. What is it called when a judge and lawyers work together and violate the rules of profession?
Okay. So there are a lot of things that they didn't do. But, okay, here's for me, from statement of facts from the state's attorney's office. They completely lied about everything. I could prove the statement of facts is false, and I did here. They said I did 10 years. Miss paper says I did 2 years and 10 months. And the state's attorney wasn't accepting it, so look, I had to correct the record myself, or get it corrected myself. And when I talked to the state's attorney's office about it, they said it wasn't on their record. See, this is a copy of the Rules of Professional Conduct from 1990, and that was before the internet, I think. Well, yeah, Worldwide Net didn't start till 93. Okay. And I was telling you about what the Supreme Court said in 1935. The United States Supreme Court described the duty of a federal prosecutor in the following passage. United States Attorney, this goes for any prosecutor, any attorney, is a representative not of ordinary party to a controversy, but a sovereignty to whose obligation is governed impartially, and as compelling as it is obligation to govern at all, and whose interest, therefore, a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he has a peculiar and very definite sense, the servant of the law, and twofold aim to which the guilt shall not escape or the innocent suffer. He may prosecute with earnestness and vigor indeed, he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is much his duty to refrain from improper methods calculated to produce a wrongful conviction. It is every legitimate means to bring about a just one. And that's what I want. That's all I want. But see, you're going to have to learn. See, when I show you this exculpatory evidence, there's a statement I've been making for years. Okay. And I've always been denied about, my right to be heard, so. Canon 2, a judge shall perform the duties of judicial conduct, impartiality, competently and diligently. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in proceeding that a person's lawyer has a right to be heard according to law. So that's what I was going to tell the judge, that, this is my right to be heard in responding to judicial or lawyer misconduct. A judge, knowing that a lawyer has committed a violation of Illinois Rules of Professional Conduct that raises a substantial question regarding lawyers' honesty, trustworthiness, and fitness as a lawyer in other respects, shall inform the Illinois Attorney Registration and Disciplinary Commission, and the judge didn't do that. In the same respect, the attorney was supposed to report the judge for judicial misconduct, for failure to abide by the Code of Judicial Conduct, as well as the judge reporting all the attorneys for failure to abide by the Rules of Professional Conduct. Okay, reporting professional misconduct. A lawyer knows that another lawyer has committed a violation of the rules. A lawyer knows that a judge has committed a violation of the rules. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or to do so through the acts of another, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, and fitness as a lawyer. So this is a statement that I made that I want you to take with you. And see, I've been through all this, ineffective assistance of counsel, motion, IAC. So people, you could take the statement and use it yourself. Motion to quash, writ of habeas corpus, writ of certiorari, Rules of professional conduct complaint form, code of judicial complaint form, deprivation of rights complaint form, conspiracy against under the color of law complaint form, ethics complaint form, post-conviction whistleblower complaint form, late notice of appeal. I got a guy out of prison in Centralia back in '91 on a late notice of appeal using a conspiracy against rights under color of law, citing judicial misconduct, ineffective assistance counsel, and prosecutorial misconduct. I didn't have evidence. All I had was the rules and the codes. Okay, but this is basically what I said. But see, for some reason, everything I put on paper seems to get ignored. And as you can see, I got quite a lot to say. This is just a whole bunch of laws that didn't happen that was supposed to happen. You know. The proceedings thus far was under duress due to disinformation, lack of disclosure, lack of informed consent. Informed consent requires reasonable knowledge to make an informed decision. To give informed consent, it would have been competent. See, I even use the rules to push them. It would have been competent, Rule 1.1, diligent, Rule 1.3, and candid, Rule 3.3, to communicate, Rule 1.4, to advise, Rule 2.1, to be fair, Rule 3.4, and show impartiality and decorum, Rule 3.5, with truthfulness, Rule point. See, this is nothing but a whole bunch of laws I throw at them. Okay. So the exculpatory evidence is on my computer, so I have to go on that, you know. And this guy complaining about, you know, just warning Americans to stop personal attacks on judges. Says it's got to stop. Stop criticizing court decisions. Criticizing court decisions is definable. Going after them judges themselves is dangerous, which I agree. Don't be going after. If you're going to go after the judge, learn the law and go after him in court. Nobody's playing by the code of judicial conduct, and that's the easiest way to get a judge off the bench. Use the code of judicial conduct, and I'm not enforcing the rules of professional conduct. That's another reason, you know. And see, rule of law is endangered. Well, that's because, look, rule of law is a core principle, meaning that all people and groups are subject to the law rather than specific penalties for any single rule. Types of penalties: money paid to the government or courts as punishment for the offense, incarceration, time spent in local jail, state, federal prison, probation, a monitored period of supervision instead of or after jail time, restitution, money paid back to fix damage or loss suffered by a victim, loss of privileges. Okay, so, you know, if they just started, you know, we all want accountability, well, how about everybody, you know, that's what I want to put in there about, you know, so the penalties for violating the rule of law, because not abiding by the oath, that's violating penalties of the rule, you know, violating the oath is deprivation of rights, that's violating the rule of law by putting themselves above the law. Penalties for violating the oath include removal from office, criminal prosecution, imprisonment, fines, and disqualification from future office. Okay, violating the letter of the law, the strict level of interpretation of statutes can result from penalties from ranging civil fines and license revocations and imprisonment depending on the severity of the offense. Penalties are often enhanced for willful misconduct compared to unintentional negligence. Penalties for violating the letter of the law.